Hi, Dr. Stack again. Just to clarify that point, yes, there's a deep concern there about the way the courts are dealing with the two nomination claims together, given the different articles relied upon to come to a determination, and the fact that there's a threshold judgment used to decide on on the issues. And it is my view that approaching it through relying on Articles 12(1)(6) and then on 34 retrospectively, that's a stronger or potentially stronger case that would lead to a higher threshold. That may be the case, but in any case, whichever one was the higher threshold should be. I feel the two should have been dealt with at the same time, and the one with the higher threshold then should have decided the other ones. And that would have been fair to both myself and Mr. Byrne, rather than unfair to me or vice versa. So, in the interest of transparency, accountability, fair play, the fact that both of us are litigants in person, I feel that what the court did here was questionable, and I think we should get an answer from the court about why they choose this decision. And I think they should tell us, why they did it this way, when everybody that I talked to said clearly that the best way to do this would have been to take the two together separately for their threshold determination, and then deciding whichever one was the best in the interest of the question and in the interest of accountability, transparency and fair procedures. So there's the issue that I'm raising. It's very, very serious, and perhaps the court can tell us why they did this, and how they're going to correct it if there is a misinterpretation. And I deeply apologise if I am the one that has the sequence wrong, or that if I misinterpreted the issue. But I think there is a duty on the Supreme Court to come out now and tell us why they aren't doing the two at the same time. Because if I was the examiner, if I was the person in charge, this is how I would deal with it, on the basis of fairness, fair play, balanced fairness, accountability, no conflict of interest, all of that, and none of this putting the weaker one before the stronger one in a way that the stronger one could be deleted or eliminated. There's a danger of that, and that may not be what's going to happen here at all, but I think there's a danger and concern. And since this is such a serious issue, I think the courts should come out and tell us what they're doing here. And if there is an issue, if they are examining both under the two different logical kind of pathways, that's fine. Just tell us that, rather than I was told that my case was adjourned pending the determination on a claim primarily based on 28, whereas mine was primarily based on 12, 1 and 6, which I felt was a stronger one for threshold. But that may not be the case, but whichever one was the stronger one should surely be the one that the two should have been examined together. And I honestly think that if I was the one in that position, I would never have done it this way. Just I wouldn't, because it would have seemed wrong. Just plainly wrong to do it this way. So perhaps I completely misunderstand, and I apologise to the powers that be if I have, but I would have considered this morally and ethically wrong and somehow suspect. And perhaps I've got the wrong end of the stick, and if I have to sincerely apologise. But I put so much work into this that I expect the highest of standards from the people, where I have put my heart and soul into getting exceptionally world-class research into this, and to be treated like this, and to feel that you have in some way been stung in the back or undermined, is completely and utterly unacceptable. But until I hear exactly what their position is, I would prefer to just say that this is all major concern, but alleged.